Human Rights and Employment, a Case Study by Laura Loam. Matheus versus McCann, Ontario Human Rights Tribunal, January 31st, 2023. What we will look at: the issues of the case, the facts, the arguments, the findings, the remedy for the case, and the implications for both employers and employees. The issue. The applicant, Camilo Matheus, alleges the respondents, Terrence McCann, the owner, and the employer, MLG Enterprises Limited, discriminated against him based on race, ancestry, place of origin, and age. Furthermore, that the respondents reprised against him, contrary to the code, after making a written complaint which led to his termination. The respondent denies any discrimination and termination for discriminatory reasons, citing 3 letters of warning and a list of concerns regarding the applicant's suitability for his job as plant engineer. The facts. The applicant is a food process engineer from Ecuador. He has a master's degree in food safety from McGill University. He began his job of plant manager at the employer, MLG Enterprises Limited, on July 4, 2016, with an annual salary of $53,000 per year. The applicant states that after the first 6 weeks of employment, the employer and owner of MLG Enterprises Limited began insulting him, making comments about his age of 27, telling him he didn't know anything and that he was uneducated. He also alleges that he threatened to fire him on multiple occasions, made remarks about his place of origin and its people. He states that these comments made him feel badly. The applicant testifies to the job requirements and his role at the company, and the incidences to which he received 2 written warnings a day apart, being cited as contrary to company policy, unacceptable, and that further violations may result in disciplinary action, including termination. The applicant testifies to 5 incidences of harassing and discriminatory remarks made by the respondent, owner, Terrence McCann, prior to the first written warning letter he was given. The applicant wrote a letter of complaint to the employer on December 1, 2016, stating the violation of his rights and that the discrimination stop immediately. And on Monday, December 19, 2016, the applicant was allegedly terminated from his position at MLG Enterprises Limited. A 3rd written letter brought forth during trial. The applicant received his termination pay around the 3rd week in January 2017. Later, he received his record of employment, which stated quit, along with 2 checks with payment for hours worked, extra hours worked, and vacation pay. The applicant believed that he was owed severance pay, as he stated he did not quit but was fired. The applicant sent out job applications, and on January 23, 2017, he found alternate work at a food processing facility in Hamilton, which was less convenient travel-wise and paid less than he made with the respondent. The applicant seeks general damages due to the loss of earnings and personal impact from both the owner, Terrence McCann, and the employer for discriminatory comments and a poisoned work environment. The applicant also seeks the owner, Mr. McCann, undergo training in human rights, and the corporate respondent, his employer, develops and adopt human rights policies. The respondents are both the owner of and employer, MLG Enterprises Limited. The evidence provided by the respondent, Mr. McCann's testimony, was inconsistent with the applicant's testimony. He admitted to making partial comments directed at the applicant during employment. He provided a harassment policy that was insufficient, dated in 2015, and did not include discrimination. He had a vague idea of where this information could be found in the physical premises and provided limited knowledge of his obligations as an employer with regards to harassment, discrimination, and makes no mention of investigation into the complaint from the applicant, only receipt of an acknowledgement of the letter dated December 1, 2016. The respondent's son, whose role in the company is sales, testifies on behalf of both respondents, stating the toxic relationship that was apparent between the applicant and Terrence McCann, acknowledging that it could be due to the alleged comments the applicant has accused his father of. He also discusses an audit to which the applicant took part in, which was unrelated to the termination of the applicant. A witness and employee of the corporate respondent was mentioned multiple times in the applicant's testimony of being present in the discriminatory comments, however, was never called upon by the respondents to corroborate their testimony. The tribunal decides the outcome of this decision on the evidence and submissions before it, as final written submissions from the respondents was not received and they did not attend the final day of the hearing. Arguments. The applicant argues that the 2 letters he received were of minor concern, that the first letter infraction was something that happens all the time by other employees, and the second letter infraction as a mistake that was caught early enough and was resolved alongside the plant superintendent. The third letter provided during trial was the first he'd seen of it and had not been given to him on the day of his termination, evident from his lack of signature and the timing of events suggesting it was written after the fact. The applicant cites Armstrong v. Anna's Hair Spa 2010 Human Rights Tribunal of Ontario in support of its position that the tribunal should draw a negative inference from the respondent's failure to call Mr. Lucetta, the plant superintendent, as a witness, arguing that Mr. Lucetta had been present when he gave Mr. McCann his written discrimination complaint on December 1, 2016 and on December 19, 2016 when Mr. McCann terminated him. The respondent, the owner, Terrence McCann, argues that after 3 months the applicant's behavior became hostile. He stated that others from outside the company expressed concerns regarding the applicant's abilities and that the applicant was responsible for the BRC audit. He testified to the errors of the applicant of which the letters referred and that the discipline policy they use is from the Ministry of Labor guidelines, and those 3 basic errors is why the applicant's employment was terminated, and that due to the applicant's hostile attitude it had to be done. The respondent argues that his wife is Colombian and his son is half Colombian and suggested he wouldn't take aim at Hispanics for this reason. The respondent argued that the applicant jumbled things up with reference to the alleged discriminatory comments made. In response to the December 1, 2016 letter given to him, he argues that the applicant never wanted to meet him halfway, and that he spoke to the applicant stating he knew he was young, inexperienced, and needed to learn, and that the letter was noted. In relation to why he did not call on his employee, Mr. Lucetta, the respondent stated that he couldn't take him away from his work. During final submissions, the applicant argues that Mr. McCann's testimony about having complied with what he called a Ministry of Labor rule, an employee can be terminated if they had 3 warnings in a month, was an attempt to make his actions look positive. The applicant submits that there was no evidence that the respondents took any steps to investigate the applicant's complaint, that no investigation was conducted, and the respondents have not met their duty to investigate, and they have violated Section 5.1 of the Code. The applicant states termination was also a reprisal for having sought to pursue his rights under the Code, as he was fired just over 2 weeks after making a complaint of discrimination and was met with a threat from the respondent, Mr. McCann, violating Section 8 of the Code. The findings. The adjudicator drew a negative inference from Mr. McCann, the owner of the respondent employer, choosing not to call his employee, Mr. Lucetta, who allegedly was present and aware of the discriminatory remarks. The adjudicator finds in a balance of probabilities that the discriminatory comments were made, as the evidence which the applicant brought forth was clear and unwavering, and that Mr. McCann's testimony did not offer a clear alternate version regarding the comments. Additionally, the adjudicator noted comments during Mr. McCann's testimony which were not inconsistent with the applicant's evidence. The adjudicator finds that the letter the applicant provided to the respondents on December 1, 2016 proves there is no dispute on the comments being discriminatory. The adjudicator found that the comments made over a relatively short span of time indicated they were regular occurrences and that the nature of the comments were, in addition to being hurtful, undermine the status and feelings of self-worth of the applicant and are of a serious nature, that this constituted a poisoned work environment. Breach of Section 5 of the Code. The adjudicator found the applicant's letter of complaint from December 1, 2016 makes explicit reference to the applicant's right under the Code and was an attempt to enforce those rights. Furthermore, the testimony of the respondent, Mr. McCann, makes it evident that the complaint was not taken seriously, investigated, or dealt with promptly and sensitively, that nothing was done to ensure a workplace free from harassment and discrimination as per the employer's responsibility under the Code. Breach of Section 8 of the Code. The adjudicator found that the letter references the applicant's rights under the Code and is a clear request for the discrimination to stop. That the applicant testified to a response being a threat by the respondent, Mr. McCann, of which he did not disagree. That repercussions after the letter was received would take place was evident, and the attempt to disguise the morning of the termination's events leads to be believed on a balance of probabilities that McCann's decision to terminate the applicant is at least in part reprisal. The remedy. The tribunal ordered that the respondent shall jointly and severally pay $20,000 to the applicant in monetary compensation for injury to his dignity, feelings, and self-respect, and shall jointly and severally pay $8,761.15 to the applicant in respect of lost wages as well as pre- and post-judgment interest. Furthermore, that within 3 months of the date of the decision that the personal respondent, Terrence McCann, shall complete the online training module Human Rights 101 available on the website of the Ontario Human Rights Commission. Additionally, the employer, MLG Enterprises Limited, within 3 months of the date of the decision, shall retain at its own expense an expert in human rights to assist in the development and implementation of a human rights and anti-harassment policy. and that the policy must be finalized within 6 months of the decision, copies being provided to all current employees and all new employees. The implications for the employer is to ensure you understand and follow the requirements of the Occupational Health and Safety Act and know your legal obligations with regards to workplace harassment and discrimination, your duty to protect your employees, and your duty to investigate allegations of harassment. Furthermore, to ensure that all employees are trained in human rights and to ensure development and implementation of anti-harassment and discrimination policies. In addition, that the owner of a company and the company itself can be jointly liable in a court of law. The implications of the employee is to be knowledgeable of your rights and responsibilities under the Occupational Health and Safety Act and your fundamental rights under the Human Rights Code. What implications might you add from this case? Thank you for watching.